The Arizona Supreme Court last week delayed enforcement of an 1864 abortion ban that the court revived in a ruling last month. Now, the 90-day delay adds another layer to an already complicated timeline regarding the ban, which the legislature just recently overturned. Here to help make sense of it all is Jennifer Pyatt. She's a research scholar at ASU Sandra Day O'Connor College of Law. Thanks for joining us.
Of course.
Thanks for helping me make sense of all this. Let's just. So basically, the court said. The court gives 90 days because the Attorney General says, what, I need 90 days to work this out?
I need 90 days to figure out if I'm going to appeal your ruling to the U.S. Supreme Court.
So basically she's saying, I think you screwed up. I need 90 days to prove it. And the court said, okay.
Yes. Yeah.
Is that unusual?
It's actually not unusual. So in cases where state attorney generals are wanting to appeal state Supreme Court judgments up to the U.S. Supreme Court, pretty often state Supreme Courts will say, yeah, of course, we'll give you that amount of time to go ahead and figure out if you do want to take an appeal up to the U.S. Supreme Court. Kind of a matter of procedure that happens pretty frequently.
Let's talk more about the procedure here as far as if and when the Attorney General goes to the Supreme Court. How does that work? What are the mechanics?
So, the Attorney General would file a petition for certiorari before the U.S. Supreme Court, essentially asking the U.S. Supreme Court to review the Arizona Supreme Court's decision because of some federal law or federal constitutional angle that she believes the Arizona Supreme Court may have gotten wrong. And then the U.S. Supreme Court can choose, yes, we're going to take up that case, or no, we don't want to take up that case.
How long would it take for them to choose, to make that decision?
It really depends. It's up in the air in terms of when they decide that, but they could very well place a stay in place while they're considering. Is that likely? I don't think so.
So they could place a stay to say, we're thinking about it. They could place a stay if they say yes. Obviously, no, they wouldn't do a stay. Mm-hmm. So even that is out there in the breeze, isn't it?
Yeah. Yeah, it's a little bit of a convoluted legal environment with all of this going on right now.
Okay, so the ban cannot be enforced for 90 days, which equals August 12th.
Yes.
But even then, there's another delay, correct?
Correct. So when all of this was first happening, when Attorney General Mark Brnovich was in office, he was involved in another litigation in trial court in Arizona. And in order to avoid all of this litigation, I mean, multiple cases potentially emerging because of this 1864 law at once, he said, okay, court, I'll make a deal with you. The Arizona Attorney General's office will agree not to enforce this law for 45 days after a final judgment from the Arizona Supreme Court, just to get rid of all this multiple litigation that's going on.
Yeah.
And the Arizona Supreme Court in this order said, our final judgment will not issue for 90 days. So we take that 90 days and we add 45-day agreement after that final judgment.
So that makes for what, like late September?
September 26th.
September 26th. Okay, so we got September 26th. That's fine. But this is for a law that the legislature and the governor have already said, get it out of here. But
yes.
That doesn't happen for a while.
Yes, so that's kind of the craziest part of all of this math. Arizona laws, when they pass them during the legislature, they don't take effect until 90 days after the legislative session ends. And we don't know when that's going to happen, whether that's going to happen in late June or in July.
Right. And
so,
it's an election year. So the idea is that they're going to get out of there relatively early. So then let's say it's late June. Then you got 90 days from there. I mean, again, I'm seeing Venn diagrams here as what's going to happen.
Yes. So if it's in late June, we already have a block on this ban until September 26th.
Right.
But if it's in, June that pushes out until September 28th, we could have like a 2-day window where that law could be in effect. If it's in July and it pushes out into October, it could be a longer window where that 1864 law is still in effect before the repeal takes place.
Yeah, I mean, like a day or something. I mean, it could literally be a day, couldn't it?
Yes.
Within all of this machinery, are more appeals possible? Could someone come out of the blue with something else?
Absolutely. There could be an entirely different court case that could come up. The U.S. Supreme Court could intervene and sort of pause this. Now, whether and to what extent those stays actually take place, highly unlikely, because there's a legal doctrine called mootness that says, you know, this case is really moot. There's nothing really to argue here. And the law has been repealed. So most likely the U.S. Supreme Court, other courts would say, we're really not going to get involved here because it's moot. This law is repealed.
I was going to ask you about that legislative intent, where that is, how that's involved here, because we kind of figured out the legislative intent. They booted it out of here. And all of these things going on as far as court cases are concerned, is that a factor at all at this stage?
You know, I think it's possible that the U.S. Supreme Court could, you know, grant a stay while this is ongoing, or could potentially take up cert. And that could, when they take up cert, very frequently they do say, we'll put this law on ice until we issue a final decision. But again, I don't think it's very likely because it's probably going to be viewed as moot.
Yeah. And now we got a ballot measure out there as well that creates the right to abortion there in the Constitution. I mean, are legal challenges there, they're just ready to pop up, aren't they?
Absolutely. I mean, election legal challenges are very, very frequent in the state of Arizona. Very often challenges on the validity of a signature, the validity of the number of signatures, because there are a number of requirements in order for a signature to be counted as valid by the state legislature. But there are also oftentimes arguments that ballot initiatives address more than one subject, and that violates the Arizona Constitution as well. So all of this potential litigation we could see unfolding as the election approaches.
As far as referrals, because there's a battle at the legislature now regarding whether or not they're going to put a referral on there for 15 weeks and do something to kind of challenge the other abortion measure. I mean, could that be challenged in some way, shape, or form? Or is that less likely?
It could be. All of these potential, you know, referral measures could be challenged on different bases. And so where we end up, Ted, is in a big morass of additional legal cases going on to figure out where we're at before the election.
Which is why we're going to ask you back if something like that happens. But the last question on all this, and we've talked about this before, this has nothing to do with constitutionality so far. It's all statute as far as what the Supreme Court decides, state Supreme Court decided, and the whole kit and caboodle afterwards, correct?
Right. But the reason that Chris Mays is bringing this whole thing up is because one of the reasons why the Arizona Supreme Court said we're making this decision is we have this statute on the books in Arizona that's essentially a statute that says we have to read all of our Arizona laws as conferring rights onto fetuses at all stages of development. That law has been held unconstitutionally vague by a federal district court. And so that's where the constitutionality issue maybe comes in for the U.S. Supreme Court, is, one of the bases that you hung your hat on, Arizona Supreme Court, is something that a federal court has already said is unconstitutional.
Interesting, yeah, because I know that she kind of mentioned that, and
Yeah.
it's been kind of there in the corner, but it's always been there, and now it could really be there at the Supreme Court. All right, thanks for clearing this up for us. We really appreciate it. Thanks for joining us.
Happy to.